8.7 Closure and opening of roads. Cabrera v. CA. Facts: the Provincial Board of Catanduanes adopted Resolution Number 158. Pursuant thereto, deeds of exchange were executed under which the province conveyed to Remedios R. Bagadian, Ferdeswin F. Alcala, Elena S. Latour, Baldomero Tolentino, Eulogia T. Alejandro, Angeles S. Vargas, and Juan S. Reyes portions of the closed road in exchange for their own respective properties, on which was subsequently laid a new concrete road leading to the Capitol building. Learning about Resolution 158, the petitioner filed a complaint with the CFI of Catanduanes for restoration of public road and/or abatement of nuisance, annulment of resolutions and documents with damages. He alleged that the land fronting his house was a public road owned by the province in its governmental capacity and therefore beyond the commerce of man. He contended that Resolution Number 158 and the deeds of exchange were invalid, as so too was the closure of the road. The judge sustained the authority of the Provincial Board to enact said resolution. The CA affirmed and found that the road was not a public road but just a trail. Also, pursuant to RA 5185, municipal authorities, subject to the approval of the Provincial Board, can close thoroughfares pursuant to Sector 2246 of the Revised Administrative Code. Petitioner insists that Sections 2246 is not applicable because Resolution Number 158 is not an order for the closure of the road in question but an authority to barter or exchange it with private properties. He maintains that the public road was owned by the province in its governmental capacity and, without a prior order of closure, could not be the subject of a barter. Control over public roads, he insists, is with Congress and not with the Provincial Board. Issue 1. The Provincial Board can validly enact said resolution. Held yes ratio. Resolution 158 clearly says that it is hereby resolved to close the old road. The closure is as plain as day except that the petitioner, with the blindness of those who will not see, refuses to acknowledge it. The court has little patience with such puerile arguments. They border dangerously on a trifling with the administration of justice and can only prejudice the pleader's cause. The authority of the Provincial Board to close that road and use or convey it for other purposes is derived from the following provisions of Republic Act No. 5185 in relation to Section 2246 of the Revised Administrative Code. It sustained the subsequent sale of the land as being in accordance not only with the Charter but also with Article 422 of the Civil Code, which provides property of public dominion, when no longer intended for public use or for public service, shall form part of the patrimonial property of the state. In the case of Favis v. City of Baguio, the power of the City Council of Baguio City to close city streets and withdraw them from public use was also assailed. This court said 5. So it is, that appellant may not challenge the City Council's act of withdrawing a strip of Lapu-Lapu Street at its dead end from public use and converting the remainder thereof into an alley. These are acts well within the ambit of the power to close a city street. The City Council, it would seem to us, is the authority competent to determine whether or not a certain property is still necessary for public use. Such power to vacate a street or alley is discretionary, and the discretion will not ordinarily be controlled or interfered with by the courts, absent a plain case of abuse or fraud or collusion. Faithfulness to the public trust will be presumed. So the fact that some private interests may be served incidentally will not invalidate the vacation ordinance. While it is true that the case is dealt with city councils and not the Provincial Board, there is no reason for not applying the doctrine announced therein to the Provincial Board in connection with the closure of provincial roads. The Provincial Board has, after all, the duty of maintaining such roads for the comfort and convenience of the inhabitants of the province. Moreover, this authority is inferable from the grant by the national legislature of the funds to the province for the construction of provincial roads. The lower court found the petitioner's allegation of injury and prejudice to be without basis because he had easy access anyway to the national road. For in fact the vehicles used by the court and the parties during the ocular inspection easily passed and used it, reaching beyond plaintiff's house. However, the CA ruled that he was prejudiced by the closure of the road which formerly fronted his house. He and his family were undoubtedly inconvenienced by the loss of access to their place of residence, for which we believe they should be compensated. On this issue, the governing principle was laid down in favas thus. The general rule is that one whose property does not abut on the closed section of a street has no right to compensation for the closing or vacation of the street, if he still has reasonable access to the general system of streets. The circumstances in some cases may be such as to give a right to damages to a property owner, even though his property does not abut on the closed section. But to warrant recovery in any such case, the property owner must show that the situation is such that he has sustained special damages differing in kind, and not merely in degree, from those sustained by the public generally. Petitioner is not entitled to damages because the injury he has incurred, such as it is the price he and others like him must pay for the welfare of the entire community. This is not a case where his property has been expropriated and he is entitled to just compensation. The construction of the new road was undertaken under the General Welfare Clause. As the trial judge acutely observed, whatever inconvenience the petitioner has suffered pales in significance compared to the greater convenience the new road, which is wide and concrete, straight to the Veterans Fountain and down to the pier, has been giving to the public, plus the fact that the new road adds beauty and color not only to the town of Viereck but also to the whole province of Kate and Dwaynes. For the enjoyment of those benefits, every individual in the province, including the petitioner, must be prepared to give his share. MMDA v. Bel Air Village Association Inc. Facts: MMDA is a government agency tasked with the delivery of basic services in Metro Manila. Bel Air Village Association, Inc. is a non-stock, non-profit corporation whose members are homeowners in Bel Air Village, a private subdivision in Makati City. BAVA is the registered owner of Neptune Street, a road inside Bel Air Village. On December 30, 1995, respondent received from petitioner, through its chairman, a notice dated December 22, 1995 requesting respondent to open Neptune Street to public vehicular traffic starting January 2, 1996. BAVA was apprised that the perimeter wall separating the subdivision from the adjacent Calayan Avenue would be demolished. On January 2, 1996, BAVA instituted against petitioner before the RDC a civil case for injunction. Respondent prayed for the issuance of a TRO and preliminary injunction enjoining the opening of Neptune Street and prohibiting the demolition of the perimeter wall. The trial court issued a temporary restraining order the following day. After due hearing, the trial court denied the issuance of preliminary injunction. On appeal, the CA rendered a decision on the merits of the case, finding that the MMDA has no authority to order the opening of Neptune Street, a private subdivision road, and cause the demolition of its perimeter walls. It held that the authority is lodged in the City Council of Makati by ordinance. Issue 1. The MMDA has authority to open Neptune Road to the public. Held no ratio. MMDA claims that it has the authority to open Neptune Street to public traffic because it is an agent of the state endowed with police power in the delivery of basic services in Metro Manila. One of these basic services is traffic management, which involves the regulation of the use of thoroughfares to ensure the safety, convenience, and welfare of the general public. It is alleged that the police power of MMDA was affirmed by this court in the consolidated cases of Sangalang v. IAC. From the premise that it has police power, it is now urged that there is no need for the city of Makati to enact an ordinance opening Neptune Street to the public. Police power is an inherent attribute of sovereignty. It has been defined as the power vested by the Constitution in the legislature to make, ordain, and establish all manner of wholesome and reasonable laws, statutes and ordinances, either with penalties or without. not repugnant to the Constitution, as they shall judge to be for the good and welfare of the Commonwealth, and for the subjects of the same. The power is plenary and its scope is vast and pervasive, reaching and justifying measures for public health, public safety, public morals, and the general welfare. It bears stressing that police power is lodged primarily in the national legislature. It cannot be exercised by any group or body of individuals not possessing legislative power. The national legislature, however, may delegate this power to the president and administrative boards as well as the lawmaking bodies of municipal corporations or local government units. Once delegated, the agents can exercise only such legislative powers as are conferred on them by the national lawmaking body. Metropolitan or Metro Manila is a body composed of several local government units, i.e. 12 cities and 5 municipalities, namely, the cities of Caloocan, Manila, Mandaluyong, Makati, Pasay, Pasig, Quezon, Muntinlupa, Las Piñas, Marikina, Paranaque, and Valenzuela, and the municipalities of Malabon, Navotas, Pateros, San Juan, and Taguig. With the passage of RA 7924 in 1995, Metropolitan Manila was declared as a special development and administrative region, and the administration of metro-wide basic services affecting the region placed under a development authority referred to as the MMDA. The implementation of the MMDA's plans, programs, and projects is undertaken by the local government units, national government agencies, accredited people's organizations, non-governmental organizations, and the private sector as well as by the MMDA itself. For this purpose, the MMDA has the power to enter into contracts, memoranda of agreement and other cooperative arrangements with these bodies for the delivery of the required services within Metro Manila. Clearly, the scope of the MMDA's function is limited to the delivery of the 7 basic services. One of these is transport and traffic management, which includes the formulation and monitoring of policies, standards, and projects to rationalize the existing transport operations, infrastructure requirements, the use of thoroughfares and promotion of the safe movement of persons and goods. It also covers the mass transport system and the institution of a system of road regulation, the administration of all traffic enforcement operations, traffic engineering services and traffic education programs, including the institution of a single ticketing system in Metro Manila for traffic violations. Under this service, the MMDA is expressly authorized to set the policies concerning traffic and coordinate and regulate the implementation of all traffic management programs. In addition, the MMDA may install and administer a single ticketing system, fix, impose and collect fines and penalties for all traffic violations. It will be noted that the powers of the MMDA are limited to the following acts: formulation, coordination, regulation, implementation, preparation, management, monitoring, setting of policies, installation of a system and administration. There is no syllable in RA number 7924 that grants the MMDA police power, let alone legislative power. Even the Metro Manila Council has not been delegated any legislative power. Unlike the legislative bodies of the local government units, there is no provision in RA number 7924 that empowers the MMDA or its council to enact ordinances, approve resolutions, and appropriate funds for the general welfare of the inhabitants of Metro Manila. The MMDA is, as termed in the charter itself, a development authority. It is an agency created for the purpose of laying down policies and coordinating with the various national government agencies, people's organizations, non-governmental organizations and the private sector for the efficient and expeditious delivery of basic services in the vast metropolitan area. All its functions are administrative in nature, and these are actually summed up in the charter itself. Petitioner cannot seek refuge in the cases of Sangalang v. Intermediate Appellate Court, where we upheld a zoning ordinance issued by the Metro Manila Commission, the predecessor of the MMDA, as an exercise of police power. The first Sanggalang decision was on the merits of the petition, while the second decision denied reconsideration of the first case and in addition discussed the case of Yabat v. Court of Appeals. Contrary to petitioner's claim, the two Sanggalang cases do not apply to the case at bar. Firstly, both involved zoning ordinances passed by the Municipal Council of Makati and the MMC. In the instant case, the basis for the proposed opening of Neptune Street is contained in the notice of December 22, 1995 sent by petitioner to respondent Bava, through its president. The notice does not cite any ordinance or law, either by the Sangguniang Panlungsod of Makati City or by the MMDA, as the legal basis for the proposed opening of Neptune Street. Petitioner MMDA simply relied on its authority under its charter to rationalize the use of roads and/or thoroughfares for the safe and convenient movement of persons. Rationalizing the use of roads and thoroughfares is one of the acts that fall within the scope of transport and traffic management. By no stretch of the imagination, however, can this be interpreted as an express or implied grant of ordinance-making power, much less police power. Ms. Juris. Secondly, the MMDA is not the same entity as the MMC in Sanggalang. Although the MMC is the forerunner of the present MMDA, an examination of Presidential Decree No. 824, the charter of the MMC, shows that the latter possessed greater powers which were not bestowed on the present MMDA. Jaclyn. In 1990, President Aquino issued Executive Order, E.O. No. 392 and constituted the Metropolitan Manila Authority. The powers and functions of the MMC were devolved to the MMA. It ought to be stressed, however, that not all powers and functions of the MMC were passed to the MMA. The MMA's power was limited to the delivery of basic urban services requiring coordination in Metropolitan Manila. The MMA's governing body, the Metropolitan Manila Council, although composed of the mayors of the component cities and municipalities, was merely given the power of formulation of policies on the delivery of basic services requiring coordination and consolidation, and promulgation of resolutions and other issuances. Approval of a code of basic services and the exercise of its rule-making power. Under the 1987 Constitution, the local government units became primarily responsible for the governance of their respective political subdivisions. The MMA's jurisdiction was limited to addressing common problems involving basic services that transcended local boundaries. It did not have legislative power. Its power was merely to provide the local government units technical assistance in the preparation of local development plans. Any semblance of legislative power it had was confined to a review. Legislation proposed by the local legislative assemblies to ensure consistency among local governments and with the comprehensive development plan of Metro Manila, and to advise the local governments accordingly. When RA No. 7924 took effect, Metropolitan Manila became a Special Development and Administrative Region and the MMDA a Special Development Authority whose functions were without prejudice to the autonomy of the affected local government units. The character of the MMDA was clearly defined in the legislative debates enacting its charter. It is thus beyond doubt that the MMDA is not a local government unit or a public corporation endowed with legislative power. It is not even a special metropolitan political subdivision as contemplated in Section 11, Article X of the Constitution. The creation of a special metropolitan political subdivision requires the approval by a majority of the votes cast in a plebiscite in the political units directly affected. RA No. 7924 was not submitted to the inhabitants of Metro Manila in a plebiscite. The chairman of the MMDA is not an official elected by the people, but appointed by the president with the rank and privileges of a cabinet member. In fact, part of his function is to perform such other duties as may be assigned to him by the president, whereas in local government units, the president merely exercises supervisory authority. This emphasizes the administrative character of the MMDA. Clearly then, The MMC under PD number 824 is not the same entity as the MMDA under RA number 7924. Unlike the MMC, the MMDA has no power to enact ordinances for the welfare of the community. It is the local government units, acting through their respective legislative councils, that possess legislative power and police power. In the case at bar, the Sangguniang Panlungsod of Makati City did not pass any ordinance or resolution ordering the opening of Neptune Street, hence its proposed opening by petitioner MMDA is illegal and the Respondent Court of Appeals did not err in so ruling. We desist from ruling on the other issues as they are unnecessary. So we stress that this decision does not make light of the MMDA's noble efforts to solve the chaotic traffic condition in Metro Manila. Every day, traffic jams and traffic bottlenecks plague the metropolis. Even our once sprawling boulevards and avenues are now crammed with cars while city streets are clogged with motorists and pedestrians. Traffic has become a social malaise affecting our people's productivity and the efficient delivery of goods and services in the country. The MMDA was created to put some order in the metropolitan transportation system, but unfortunately the powers granted by its charter are limited. Its good intentions cannot justify the opening for public use of a private street in a private subdivision without any legal warrant. The promotion of the general welfare is not antithetical to the preservation of the rule of law. Sangalang VIAC. MMDA claims that it has the authority to open Neptune Street to public traffic because it is an agent of the state endowed with police power in the delivery of basic services in Metro Manila. One of these basic services is traffic management, which involves the regulation of the use of thoroughfares to ensure the safety, convenience, and welfare of the general public. It is alleged that the police power of MMDA was affirmed by this court in the consolidated cases of Sangalang VIAC. From the premise that it has police power, it is now urged that there is no need for the city of ordinance opening Neptune Street to the public.